You've probably seen stories about new age verification laws and assumed they were still a long way off from affecting your life. But in California, that system is already taking shape, where the devices you use every day may be forced to know your age, sort you into a category, and then share that information with both apps and cops behind the scenes. And once that infrastructure is in place, it won't stop in California. Other states are already moving in the same direction. And if people wait before it reaches them, it'll be too late to stop a nationwide surveillance system that will take over every device we use. I'm Jeff Hampton, the People's Lawyer, and in this video, I'm going to break down exactly what this new California law does, why I believe it crosses a constitutional line, and how a law that starts with protecting children ends with every American being tracked, categorized, and watched through the devices they use every day. But let's start with what this California law actually says. It's called Assembly Bill 1043, the California Digital Age Assurance Act. Governor Cuomo signed it in October of 2025, and it goes into effect January 1st, 2027. Under this bill, before you can use any device connected to an app store, you're going to be required to put your age or your specific date of birth. You will not have the option to skip this. And under the law, it's mandatory. And it's not just Apple, and it's not just Google. This applies to any company that makes software that your device runs on. Once you enter your age, the device doesn't just store it, it actually divides you into a category. Under 13, 13 to 15, 16 to 17, or 18 and up. And here's where it gets scary. That age category doesn't just sit on your device. Every app you download can ask for it every single time you open an app. So think about that. Every time you open an app, your device is basically sending out a signal that says this user is in this age bracket. Not one time, not occasionally. It's doing this constantly. And this goes way beyond smartphones. The law is written so broadly that it covers anything with an operating system that could remotely be tied to an app store. Your laptop, your desktop, your smart TV, your gaming console, even things like smart appliances or a 3D printer. If it runs software and is connected to an app marketplace, the device is required to know your age, and it can share it with almost anyone on demand. Companies that mess this up can pay fines up to $2,005
Won't somebody please think of the children?
and up to $7,500 per child if it's intentional. And although all of this is going to be enforced by the California Attorney General, this is not something in theory. This is something directly in practice that all California cops will have access to. So now they can become an enforcer of this new law. You say, okay, Jeff, who cares? Maybe this is a good thing. After all, it sounds like it's designed to protect children. Won't somebody please think of the children? The problem is, like many laws passed by legislators, many times they don't consider the law of unintended consequences and the effect it will have on your constitutional rights. In fact, the law is starting to wreak havoc immediately, and it hasn't even come into effect.
Won't
Apple
somebody
is saying they're
please
not
think of the
waiting for the
children?
law to kick in. They're putting age verification systems into place before January 1st. And that should scare you because none of this is really about age. What Apple and other tech companies are building is a system, a framework. They may claim they're here trying to protect kids, but in reality, it's a system and framework that benefits them. Think about it. Your device identifies you, sorts you into a category, and then shares that information with every app that you use. Today, that category is your age, all in the name of protecting children. Won't somebody please think of the children? Tomorrow, it could be your location, your search history, your political views, maybe your religious beliefs, maybe even your health data. Because once the infrastructure is in place, the hard work's already done. At that point, it's just a question of when the police can get access to it. You say, Jeff, this is wrong. These tech companies should fight back. Not a chance. There's a project called Midnight BSD. It's an open source operating system that's completely free and volunteer run. They just announced they're blocking all California users, not because they want to, but because they can't comply with this new law. They don't have the money or the manpower to build this kind of system. So instead, they're cutting off access to 40 million people. Projects like Ubuntu, Fedora, and Linux Mint are trying to figure out what to do here. These companies are open source operating systems that value your security and your privacy. And they're considering pulling out of California entirely. Think about that. Free software providers built to be available to anyone everywhere, suddenly off limits based on where you live. And who do you think it helps? Who do you think gets hurt when free software isn't available? But what happens when this gets in the hand of the cops and they realize they can use all the legal loopholes available to them to now violate your potential constitutional rights? Now, here's where I think this law violates the Fourth Amendment. If you remember the good old Fourth Amendment to the United States Constitution, it says that we have the right to be secure in our persons, houses, papers, and effects from unreasonable searches. Now, your phone is considered an effect under the Fourth Amendment, but it's not just any effect. It's the most personal thing you own. Your messages, your photos, your finances, your medical information, your location history, your entire life is sitting in that device. And the Supreme Court agrees with me. In Riley versus California, the police arrested a guy and searched his phone without a warrant.
No, stop.
The
Think of
Supreme
the
Court
children.
ruled unanimously 9-0 that the cops could not just search this man's phone without a valid warrant. Not after an arrest, and certainly not for officer safety. Unless you give cops consent for them to search your phone, they can never search your phone without a warrant. Chief Justice Roberts wrote, "Modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life. That's the standard." So now, let's tie this to the California law. If the government can't even look inside your phone without a warrant, how can it force you to broadcast your personal information to every app that you use? This law seems like a clear constitutional violation to me because the language of the law requires your device to collect personal information about you and then broadcast it to third parties without a warrant, without probable cause, and even without reasonable suspicion. And the worst part, you can't opt out. That's not just data collection. That's a warrantless digital search dressed up like safety precautions. No, stop, think of the children. But even if the Supreme Court rules that Riley versus California does not apply to this California law, there's another reason I believe it violates the Fourth Amendment. Real quick, you see this thing right here? This is the Plod Note Pin S. I wear it every single day, every meeting, every strategy session, every conversation that matters. This thing is recording, transcribing, and summarizing it for me automatically, all powered by AI. And here's why I bring it up to you. As a criminal defense attorney, I tell every single client the same thing. Document everything, record your interactions, protect yourself. But most people forget, or they fumble with their phone, or their audio is garbage because their phone's in their pocket. Or maybe you want to keep up with your new ideas, sales calls, or meetings with your friends and family. Plod covers it all with AI insights. The Plod Note PS clips-on has dual mics with noise cancellation and captures clear audio without me needing to touch my phone. When I'm done, it gives me an AI-powered transcript with speaker labels telling me who said what. But what I like the most is that it doesn't just give me a raw transcript. You can choose different templates depending on your situation. So instead of messy notes, you get structured summaries that actually make sense for the conversation you just had. It isn't magic, but it's amazing tech. It's smaller than AirPods, but it runs for up to 20 hours continuously. I can finally actively listen in meetings without having to take notes or missing details. And this is the part I use all the time. I can search months of recordings with just one question, and it takes me straight to the moment that I need. I literally use this device every day, and if details matter to you, and they should, check out Plod. Links in the description. Under Carpenter versus United States, the police wanted to access historical cell site location information from a suspect. That's the data your phone creates when it connects to cell towers. showing every place you've been. The Supreme Court ruled there that accessing 7 or more days of that data required a warrant. And this case is really important because Chief Justice Roberts recognized that digital surveillance is fundamentally different from traditional surveillance. He wrote that cell phone location data creates, quote, a comprehensive record of a person's movements, and that this kind of pervasive surveillance always should require a warrant, because this cell tower data creates a comprehensive picture of your whole life. And this California law is likely going to do the exact same thing. Every time you open your app, your device tells the government your age category. This isn't a one-time data point, it's a constant signal. Over time, that builds a profile, not just where you go, but who you are and what services you access. That's the exact kind of pervasive surveillance cops have been itching to grab a hold of. But here, they've dressed it up all in the name of protecting the kids. You say, wait a minute, Jeff, even if the Supreme Court rules this to be unconstitutional, you've talked about the third-party doctrine. Can the cops use this loophole to still track us? The old third-party doctrine comes from the case Smith versus Maryland. The idea is simple. If you voluntarily give information to a third party, that information is no longer private and can be accessed by the government without a warrant. So, with this California law, the cops are guaranteed to argue you gave your age to the device. That's voluntary, and we can get access to that information because you voluntarily gave it up. But if they make that argument with this California law, they'll forget about the one limitation that was carved out in Carpenter. The court recognized that in the modern world, there can be times where you never really choose to share your data, especially when your device does it automatically just to function. And the court in Carpenter ruled that this kind of automatic data sharing doesn't automatically wipe out your Fourth Amendment rights, thus creating a bit of a shift and a change in that third-party doctrine. So, if this law can just get appealed and brought to the United States Supreme Court, it looks to me like it clearly violates that standard. In fact, if you read the specific language of this law, it is the absolute definition of compelled data transmission. You had no choice. That's not voluntary disclosure. That's government-mandated surveillance. And the final question we have to ask to determine if this California law is legal is, does it meet the reasonable expectation of privacy test set up by Katz versus United States? Here's the real test. Do you reasonably expect that every time you open an app, your personal information is being broadcast behind the scenes? Of course not. No reasonable person believes that merely opening an app creates a massive broadcast signal, basically telling all the other apps and anyone else who's tied in exactly who you are. So based on all Supreme Court law and standards, this California bill, it really needs to die. But here's what scares me the most. This isn't going to stay just in California. We all know that California tends to set the tone when it comes to things involving technology, and then it spreads like a cancer to the rest of the country. When California passed its new emission standards, the auto industry had to comply nationwide because it's too expensive to build two different cars. California is the fifth largest economy in the world. Not in the United States, in the world. When California passes a technology law, all in the name of the kids, you can guarantee many states will follow, and our privacy rights will go down the drain. And unfortunately, it's already spreading. Texas has already passed its own App Store Accountability Act. Utah passed a similar law, and it's not stopping at the state level. There's a federal bill out right now known as the Kids Online Safety Act. It's moving through Congress right now, and it's basically the same California AB 1043 on the federal level. And the worst part is that this infrastructure, this tech infrastructure, it doesn't go away. Once every device in America has a built-in system to both collect and transmit data to apps that you use, that system will never go away. Today, it's your age. Tomorrow could easily be your location, your browsing history, your beliefs, your full identity. And at every turn, the justification will always be the same. It's for your safety and for the children. Won't somebody please think of the children? So, what can you do right now to protect yourself and your family? First, if you're in California, it's time for you to speak up. The 2026 legislative session is still open. This law does not go into effect until 2027, which means the law can still be changed. Call your assembly member, call your state senator, tell them exactly how you see it. This is government surveillance dressed up like child safety, and you want it repealed or amended. Second, start protecting your data. Use a VPN, hide your location, and encrypt your traffic. In fact, lawmakers in Wisconsin tried to ban the use of a VPN through their child safety bill. The backlash was so strong they had to backtrack. That alone should tell you where this is heading. Number 3, look at alternatives. Options like Ubuntu or Fedora are still figuring out ways to get around this law. And then you have options like Graphene OS, which are designed specifically to give you more control over your data. These tools exist and they put some power back in your hands, which brings me to number 4. It's time for you to lock down your permissions. Go into your settings and look at what your apps can access. Your camera, your microphone, your locations, your contacts. If an app doesn't need it, turn it off. This is one of the simplest things you can do, and most people never do it. Number 5, support people fighting back against these laws. Groups like the Electronic Frontier Foundation are pushing back against terrible laws like this. If this matters to you, share their work and amplify what they're doing. Which brings me to number 6, know your rights. The Fourth Amendment to the United States Constitution protects you, but only if you use it. If the cops look at you and demand to search your phone, look back at them and say, "I do not consent to searches. Am I free to leave?" And finally, always fight this in court if you need to. If cops ever try to use your collected data through a law like this, it's time you fight back because the Constitution is on your side. Your device is protected. Persistent surveillance requires a warrant. You have a reasonable expectation of privacy, and the government cannot force you to disclose personal information just to live your life. Now that you've seen how this California law can force your device to broadcast your personal information to the cops without a warrant, what if I told you that the cops might not even need a law to get away with this? In fact, cops are already tracking